What's up, everybody? And welcome back in. We've got more Sarah Boone news as we've read all the motions. We've read the judge's orders setting dates. We've read the JAC's response. And now we get the ruling from the judge specifically on Sarah Boone's motions. She wins some, she loses some. The important one is the standby counsel, which there's some pretty good explanation, discussion on that. We also get to see Sarah Boone arguing on her behalf in person, in living color for the first time. And I'm very interested in that and interested in your take on that, because I know I have some feelings on how she did and how the interactions went with the judge and the state attorney. So make sure you guys get your questions ready. Make sure you hit that like button and let's jump in to this hearing together. So we're going to skip the first like 5 or 7 minutes where it's just the judge introducing everybody. The JAC saying they have some sample motions that might help Sarah Boone in the future. And you'll see how everyone is incredibly nice to Sarah Boone throughout this entire hearing. We'll talk about why. And the judge, right off the bat, Sarah Boone's going to win the motion for asking for money for an investigator, as they've already cleared $5,000 for the investigator that's already working on the case that Sarah Boone already knows about. That she didn't know about at the time she filed the motion, but knows about it now. Additionally, the judge said we're going to need a lot more specifics on the motions with the depositions and with the hearings and with the witnesses. Sorry, not the hearings, the depositions, the witnesses, the experts. We need a lot more information on that, but he's going to deny them without prejudice. So technically a loss, but it's not really a loss. A lot of quotes here. She wins one where he already granted money. She loses one, but he says without prejudice because she can refile it, asking for that information again when she has specifics. Who are the witnesses? Who are the experts? How much money does she need? Why does she need it? Some have already been approved. They point out some to her throughout this hearing that we're going to listen to. You know, everybody's got suggestions and they're so helpful to Sarah Boone. And my thought is, yeah, that's all nice and good. But what that should indicate to you is how bad this is. They know she's going to lose. They know they're going to beat her when you look at the state. The judge knows how impossible of a task this is. So they're going to bend over backwards to be helpful to Sarah Boone. But don't get it twisted. Nobody in the room is going to help her win. They all know at this point, there's a 99.9% chance she loses. Because when you put people in situations like this is why judges usually beg people not to represent themselves. You're going to hear them talk about different hearings and colloquies and things that happen in this situation that aren't going to happen for Sarah Boone because she didn't waive her right on her own, but instead constructively waive it according to the judge. And so she doesn't get some of those hearings and colloquies. And we'll also hear how that affects standby counsel. But we're going to start about 7 minutes in. It's about an hour and a half for us to watch together. So I have it sped up. If you guys want to slow it down, hit this gear box right here on the video you're watching of me. It'll slow it down to whatever pace you want to listen to it to. I'm going to try 1.75. If it's too fast, I'll bump it down to 1.5 just because I want to watch this whole hearing together and I don't have 2 full hours to hang with you guys, but I do have an hour and a half. So we'll get as much done in an hour and a half as we can.
That we're seeking in that motion is to provide immediate relief to the defendant by appointing effective standby counsel to aid and support the preparation of her criminal case for trial. State, do you have any position with regard to Ms. Boone's request for standby counsel?
No, Your Honor, what's already been placed on record in the court's order.
Okay. Mr. Lake, anything over?
I will bump up the sound a little bit here just in case it's a little low.
Rebuttal to your response?
Just briefly, Your Honor, the point we would make, Your Honor, is I think Ms. Boone misunderstands the role of standby counsel. Standby counsel is not co-counsel or assistant counsel to a defendant. Standby counsel is there for when in a situation where a pro se defendant.
Probably a little too fast. I'm going to bump it down to 1.5 and we'll leave it here. You guys can slow it down more though, of course. This is the JAC representative here on the screen. And he starts out by saying, I think Sarah Boone misunderstands what standby counsel is. I think he's right. She thinks it's somebody that's going to do everything on the case for her. I hear everybody saying too fast. And just so you know, on your video, you can click this gearbox right here and you can turn it down to 0.5 speed if you want to, or 0.25 speed. But so he says she misunderstands what standby counsel is. I agree. I think she does misunderstand that. To what extent we can all kind of disagree or discuss in the chat, but it's very interesting to hear him define how she thinks standby counsel works.
Was elected to represent herself, decide at some point they want a lawyer, that allows the court to put a lawyer back into play at that point in time. In other words, it's a safety mechanism so that if a defendant who is decided to represent themselves decides at some point they no longer want to represent themselves, the court has a lawyer already in place so that the progress is not delayed. It is not an assistant or a co-counsel. It is someone whose role is essentially not to get involved until the defendant says, I no longer want to represent myself.
Ma'am, the court's had the opportunity to review the case law on this issue. There is no constitutional right to stand by counsel as decided.
So what do they say? He says standby counsel is there for somebody who has waived the right to counsel so they can have somebody ready to jump in if they decide not to use standby counsel, right? So if they decide not to use standby counsel, somebody's right there. They already know what's going on. They can represent them because it is their right. But the problem is the man on the screen works for JAC that we read. He's the one that responded to the prior motion that we read. So what I think is really interesting about that is she's in a situation where she has not waived her right. So she can't choose to let standby counsel take over, or she would obviously do that because she wants to. So yes, you can. You 100% can slow down the live. You 100% can. You'll be a couple minutes behind at the end, but you absolutely can slow it down as much as you want. So this guy is saying that the standby counsel does not replace your appointed counsel. And that's what Sarah Boone wants. She wants appointed counsel. He's right. We know it. The judge is about to give us his understanding of what standby counsel is and whether or not he will allow it. All right. People are saying they can't on their phone. All right. I'll slow it down a little bit. I don't know if I'm going to be able to listen to the whole hearing now. So we'll just get through as much as we can at 1.25 speed. It is fast. I agree with you guys. It is fast. I'm not trying to play it at a speed you can't listen to. I'm doing my absolute best to do it so you guys can hear the entire hearing, but also with some explanation mixed in. So I have limited time. Maybe we can do it in 2 parts, but I'll put it on 1.25 speed. Yes, I see people saying on their phone. I get it. All right. I'll slow it down a little bit.
By Paul versus State 152. So there is no constitutional right to stand by counsel as decided by Paul versus State 152, Southern 3rd, 635 at pinpoint 641 by the Florida 4th District Court of Appeal in 2014, citing to the Florida Supreme Court case in Jones v. State 449 Southern 2nd, 253 at pinpoint 258 from 1984. As the court has determined that you have forfeited and alternatively waived by your conduct the right to court-appointed counsel, the court is not required to appoint standby counsel. That's Brown v. State 45 Southern 3rd, 110 at pinpoint.
So you can see where this is going, right? You guys have learned to pick up on this by now. Number one, no constitutional right. The court does not have to provide standby counsel. So what is he doing? He's making a record. He's putting it all on the record. Why? Ultimately, he is going to deny Sarah Boone standby counsel.
114 through 115, Florida 1st TCA 2010, citing to, again, Jones v. State by the Florida Supreme Court in 1984. There is no Sixth Amendment right to simultaneously proceeding pro se and with legal representation by the Florida Supreme Court in 2009 in Shepard v. State, 17 Southern 3rd, 275 and 279. For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied.
He's like, you don't have a right. I don't have to. Standby counsel denied. Now, I love this judge's disposition. I like how he does this. I hate to see somebody forced to represent themselves. I'm being honest. In case you guys haven't figured that out yet throughout this process, I keep saying, give her one more chance, give her one more chance. I hate it. I don't want anybody to take advantage of the system, but she's losing now. She's going to lose. I'll just tell you, unless something crazy happens, again, 0.01% chance she wins. Everybody in that courtroom basically knows she's going to lose. So they're going to give her every benefit of the doubt. But in case you think the judge is reconsidering his prior ruling, he's not. And he's making it clear by saying, no standby counsel. I wish he would have given it. I would have given it if I was the judge. I'm not the judge. Maybe this is why. And just so it's like she has somebody to ask, like, hey, where is this document? Or how do I get this to the judge sooner? I am sure, minority report style where, we can predict the future, that she would abuse standby counsel. Like the JAC said, basically treat them like they're her co-counsel or her assistant counsel, which they're not. And that would be inappropriate. So I understand why they might not want to do it for that reason. But gosh, to throw somebody in the deep end when they don't even want to. It's one thing when Darrell Brooks and he's like, yeah, I want to handle this myself, judge, I got it. And they try to talk him out of it and they can't. But from her perspective, they're kind of forcing her to, and she's saying they forced their hand, or she forced their hand. But, we're in a very interesting predicament here that the judge has made this decision, and we're going to see how it all plays out. But keep in mind throughout this entire hearing how helpful they are to Sarah Boone.
Do you have any other questions, ma'am, as to the court's rulings this morning?
First off, I did not forfeit my right. That was your judgment. And also, I feel that I should have had some type of evidentiary hearing prior to your decision, so I could have better explained myself and you could have had a better understanding. So by you denying my standby counsel, which thank you to him for explaining to me what specifically it is, I don't want to be pro se any longer, so I didn't want to be pro se in the first place. And again, you, in my opinion, unlawfully denied me or didn't even suggest an evidentiary hearing for me to avoid or try to go about a solution or remedy to even understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity, or if it's just something that is denied, period.
It is denied.
So she said there should have been an evidentiary hearing. I should have been able to plead my case. You didn't let me. You forced me to be in this position. I did not waive anything. I did not choose to be in this position. This is not what I want. Kieran, yes, it is quiet. She doesn't have a mic on her. So that's how it is. I've boosted the sound as much as I can. And I'll repeat what she says as we kind of go through the analysis. And she says, I want to be able to argue it, Judge, because this is wrong. And he said, denied. This is not the last time it's going to come up. They're going to continue to talk about it. Reese's mom said, time for a plea bargain. Well, we're going to see maybe more on that. And Sunset said, yes, pro se defendants have won. Absolutely, they have won. They have won plenty of times. Very rarely in situations like this. Very rarely. This is going to necessitate a technical defense because she did the actions they're accusing her of. But she's saying there are other reasons why she did it, or having to prove her intent in mens rea and how that technically works in the different causes of action it could potentially be with lesser included. Didn't the JC say he was giving her a pro se packet? Yeah, so he's going to give her packets and documents and sample motions for her to be able to use and fill out, but he's not going to do it for her. And under his opinion, the standby counsel had already been denied. Turns out he was right. I don't know if it had already been denied, but it was denied today. Jilly, aren't all pro se defendants incarcerated? No. I don't know why there aren't procedures already in place for this stuff like evidence viewing, debacle, etc. So it's very, very, very small percentage of cases. Most of the time they're incarcerated, but not all. That's not some kind of requirement. And we really, as a system, if I'm being honest with you, don't want to set it up to make it so easy for somebody to be pro se, or not easy, but something that more people would do, because we know how much of an uphill battle it is. So even if we put these great procedures and protocols in place, it's still much worse than them having a defendant, criminal defense attorney. What we do though on civil rules, I'll say, is there's different things like landlord-tenant types of actions, even family law, where we do a lot of forms and a lot of things to help pro se litigants on the civil side, because a lot of times it doesn't make sense or people can't afford, because you don't have a lawyer appointed for you on the civil side in Florida. So we try to make it a lot more amenable and a lot better and easier for pro se litigants to be able to handle it on their own. It's very different in a criminal defense case. And we don't want to encourage people to make a decision that we as a society think is a bad decision, right?
Period. With regard to an evidentiary hearing, that seems to be in the realm of a Ferretta inquiry, where a criminal defendant is seeking to represent themselves. And I would inquire of that person and have an evidentiary hearing as to the rights and remedies that you were forfeiting, and the pros and cons of proceeding representing yourself, and the benefits of being represented by counsel. Due to the Florida case law that was provided in the 16-page order, no such evidentiary hearing is required.
My understanding was the hearing, the Ferretta hearing, is in regards to competency as opposed to.
They mention a Ferretta hearing, and again, this is when you start to see, and I notice it. Maybe just because I'm a lawyer. I don't know if you guys notice it as lay people, but I would be annoyed if I was a pro se defendant and not a lawyer, and they start throwing out Ferretta hearings and stuff like that, which is, similar to what we've seen in Darrell Brooks and other pro se cases where they, tell them everything, make sure they want to, make sure they're competent, make sure they know what rights they're waiving, all that stuff. And they drop that, little breadcrumb, but she picks it up and she said, I thought that was incompetency. Now she's wrong, but she's heard Ferretta hearing. She's looked into Ferretta hearing. She knows something about Ferretta hearing, or has talked to somebody about a Ferretta hearing, and she gives it back to the judge, which tells me she is absolutely competent. as far as pro se litigants go and pro se defendants go, she's going to be on the higher end. Whatever you think about her, she's going to be on the more competent end, in my opinion. And I think she's shown that with her documents that she's filed and in her first time in court. So keep an eye on that as we listen as well.
Understanding before you take someone's right to win.
That pertains to a criminal defendants seeking to represent themselves. Ferretta was not applicable to your situation, and that's identified in the case law citations that were provided in the 16-page order.
So he's like, that's why I did that long order, and I cited it because Ferretta doesn't apply to you, because Ferretta is when somebody is waiving their right, and we have to make sure they're waiving it knowingly and voluntarily. You constructively waived yours, not knowingly and voluntarily. And again, this is where it gets all muddy and gray, and this is abnormal. This is not what normally happens in cases like this. D-Trug said she chose this by her conduct, by refusing to work with any of the appointed attorneys. I'm out of sympathy for her. I totally get it. I totally get it. And I really wish she would have acted differently with Cashman. I think they could have worked together and Cashman could have provided potentially the best defense that's possible for Sarah Boone in her situation. JLo5, how does jury selection work with pro se? Just like it does with lawyers. She can get up there and ask the jury questions. Now, what the heck does she know to ask them? I don't know. I bet she's going to ask about media coverage. I bet she's going to ask, has anybody watched anything about the case or read anything about the case? That would be my guess, but I don't know. JD said, I agree. She has brains, but she's difficult. Oh, yeah. This is a great comment right here.
Yes, I understand. It was the day of that I was explaining most of all of this, and as opposed to prior, so I would know what happened or could happen. So my understanding is one thing, and then the explanation is another. So I'm just confused and feel that I should have had an opportunity prior to all of this to explain myself and to have a better understanding. So now my belief was that the Ferretta hearing was simply competency. So the evidentiary hearing I thought would be a collaboration of the information of why I wrote my letters in order for you to remove my right to counsel. In my opinion, I felt that it was a type of retaliation by the court because you did not understand or attempt to understand any of my letters that I wrote previously, which was for the.
Never a good sign when you say the court was retaliating against you, number one. And then number two, you just didn't understand what I was writing in my letters. Now, a misunderstanding can sometimes be clarified by an oral argument. Lawyers do it all the time. We file a brief, we write it, but then we also argue it orally. We answer any of the judge's questions. So she's got a point there. But to say the judge was retaliating and things like that, I mean, that doesn't give a judge the option when it's up to his discretion to be like, you know what, I'll let you argue it again, because then you're just going to say I retaliated again. So what's the point? We're not doing this, is eventually what he says.
Intervention of the judge and or the court to avoid any of this with me sitting in front of you present.
Ma'am, as identified in my 16-page order, I listened to every audio hearing. I specifically provided dates and times and words that were specifically said at particular hearings involving yourself and prior counsel. I also made reference in the 16-page order to statements that were made in your letters. I promise you, I've read everything in the court file. I've read every single letter, and I've listened to every single audio. That decision was not made lightly, and it took a lot of time to make that determination and that decision, which explains why it was also a 16-page order. That order stands, it remains. The court's not going to revise its findings or its determination as to your forfeiture, and alternatively a waiver by virtue of the conduct identified in that order.
He's like, I'll do you one better. I read every single thing. I listened to every single thing. I know every single thing in this file and on your docket. I'm not retaliating. My order is final. I did a lot of research. I put a lot of thought into it. That's why it was 16 pages, which is a long order for a state court judge in a situation like this. Denied. I am not changing my mind. We are not rehearing this issue. It's done. You're representing yourself. So just in case there was some wiggle room, just in case you're one of those parents, which I am sometimes, that when your kids argue, you're like, all right, fine. He's like, I'm not that kind of judge. That ain't happening here. Yeah, I love it. And the reason I love it is not because, I want something bad to happen to Sarah Boone. The reason I love it is I like a thoughtful judge who does the research, thinks about the best way to answer it, gives their answer, and sticks with their answer. Let your yes be yes and your no be no. Then it's consistent. We know what to expect. I would love to try cases in front of this judge, in front of judges like this. I know him from mock trial. He coached a team. I was the mock trial chair. That's how I know him. I've never tried a case in front of him. But I know Azam, I think, asked that earlier. But you can just tell the way he is. And I like that. I respect that. And even if I disagree with the judge's order, I know that he was going to think about it, research, and come up with the answer he thinks is the right and just and correct answer.
I believe, in my opinion, the order is erroneous, and after I reviewed your 16-page order, there are quite a few incorrect entries, and some of them are based on perjury by the attorneys. And by you reading and then also listening to the audio, you did not listen to me in any way, shape, or form in order for me to explain myself better, so you have an exact understanding of the particulars of each letter for each attorney.
I'm not going to revisit my prior decision.
I understand. I'm just trying to make you aware that it's my opinion.
You, and like we talked about last time, and you're certainly entitled to that opinion.
Thank you.
All right, before we move on past standby counsel, a couple people have points about competency. I think Sarah confuses competency with being qualified. She thinks she can get out of it by claiming incompetency. She's definitely not qualified to do this, but she's competent. Absolutely hit the nail on the head. Olga said, are you required to go through a psychological test before you waive your right? It's sad to see. Only if somebody orders it, like if the judge or one of the lawyers is like, hey, I don't think they're competent to do this, then you'll have to go through that. Logan, I am going to be heartbroken if she takes a deal. I'm in Orlando and want to watch live. We'll have to figure something else out for my, I think it was 200,000 subscriber celebration thing or whatever. I was going to go watch a day of this trial, but we'll have to figure something else out if she takes a deal. We'll talk more about that in a little bit. Sarah in shock and horror. I've watched this already. The judge has an incredible level of patience. Sarah Boone effed around and is now finding out. This case will likely be studied in law schools for years to come. Thank you for giving us your thoughts. So anybody that thinks this judge is, I agree with you, he's very patient. Anybody that thinks this judge is a jerk and he wanted to hammer Sarah, or he was retaliating, or he was just doing this to be mean or whatever, he wasn't. And I think you can tell he's thoughtful, he's kind, he's patient on the bench. I don't know about, necessarily personally or whatever, but on the bench, he's kind to her, he's respectful to her, he's patient with her, but that doesn't mean he's going to be soft. That doesn't mean he's going to bend a knee. That doesn't mean he's going to do things that he knows are wrong. He's still going to do the right thing. Whatever the law points to, and you're going to hear a couple times in this hearing, he's going to be like, I got to go do more research before I can give you that answer to make sure I'm giving you the right answer.
Jail, Sergeant Donald Casey, who is on his way from prison break investigations. I do see that Mr. Lane is present. So as soon as he gets here, we'll be able to address that exchange. What we can do while we're waiting for that representative to appear is address some of the things that were identified in the notice of hearing for today, which is kind of a scheduling conference for when we might be setting up certain deadlines. As of right now, the trial is scheduled for October 7th. The trial will be extended from 2 weeks to 3 weeks. So the trial will take place on October 7th, October 14th, and the third week of October 21st. October 21st is not this division's normal trial week.
Did you catch that? This trial went from a 2-week trial to a 3-week trial. Why do you think that is? Purely pro se defendant. My half-day pro se trial, the only case I ever tried against a pro se defendant when I was a prosecutor, a half-day trial went to a full 2 days. So it was 4 times longer than it should have been. It was a very simple misdemeanor, nothing. But because it was a pro se defendant, it took forever. So this 2-week trial is now 3 weeks purely because there's a pro se defendant. It's just what happens. It takes longer. A lot more explanation, a lot of patience, a lot of working together.
However, the court has obtained coverage for that week so that should this trial proceed into a third week, we will not have to scramble in order to find coverage, and that we'll be able to efficiently proceed with any evidence or testimony on that third week on October 21. Pre-trial was scheduled for September 24th at 1:30. The court typically has its regular trial case managements on that Tuesday. Due to Ms. Boone representing herself and some of the complex issues that may be involved in this case, I'm inclined to change the date of the pretrial so that we might be able to have our own pretrial separate apart from all the other cases that may be set for that same trial period.
Once again, usually we do a bunch of the pretrials on the same day. Lawyers come in, we talk about what the issues are. We go to the next one. It's 15 to 30 minutes, maybe an hour if it's a complex case. He's like, we're going to need more time. So I'm going to kick it back. I'm going to give her a couple extra days. He ends up doing it 2 days later, but it's specially set for this case to give her more time. Special treatment, you should say, or you could say, but in reality, she's getting all this special treatment. She's getting all this help. She's getting all these pats on the head because they all know how bad it is for her.
My thought would be to move it to, rather than the Tuesday the 24th, to Tuesday the 26th at 9 a.m. for trial as well. Are you amenable to changing that date to September 26th at 9 a.m.?
So an additional 2 days?
Correct. You would still have that time to prepare regardless if we had the hearing on September 24 or September 26. I'm just moving it so that we don't have 50 or 60 other cases and I can focus more attention on your case specifically. All right. So pretrial will be rescheduled till September 26th at 9 a.m.
And she gets it, right? She gets it. She definitely wants to be argumentative, and she wants to, fight for herself and advocate for herself, which, people can respect. But she figured it out. He's like, I'm doing this for you, man, to give you more time. She's like, oh, okay, yes. I'm not going to put my foot in my mouth here.
One of the issues that I wanted to address was deadlines for production of the state's exhibits and the defendant's exhibits. Now, I'm mindful, Ms. Boone, that you have not reviewed some of the documents that may have been provided. I know most recently, Ms. Cashman spent 20 hours with you alone going over questionings and reviewing some of the materials. I don't know the breadth and scope of what was reviewed to you, but some of it may have been reviewed to you based on counsel's representations. State, I want to address with you first, because Ms. Boone hasn't reviewed the discovery yet, as to what your position is with regard to assembling or finalizing an exhibit list or your exhibits for trial.
As far as providing a list of the specific items that the state seeks entry of?
Correct. I do want it before pretrial. So let me just kind of lay the map for what the court's thinking. The court would have the state provide a exhibit list and a witness list by X date. Ms. Boone would have the opportunity to look at that list. We would then have a hearing where all of the exhibits would be shown to and provided to Ms. Boone. They would be provided on a USB thumb drive that could be utilized with a
By
laptop.
the way, we do this in every civil case. We exchange exhibits. We say which ones we object to all the time. It's a little different in criminal. We do exchange. They do still do the same thing, but it's a little more open. Things, happen and move, and we've seen that in trials. But he's basically trying to make it more like a civil exchange. But the state's like, I don't want to be tied down by this. And the judge is like, well, we'll leave it open for you to be able to respond. And we'll listen to them go back and forth a little bit, but I'll point out some of the fear I think that the state attorney has in this situation.
Laptop at the jail. And then she could view all those exhibits here in open court. And then she would be afforded the opportunity to make objections in writing to any exhibits at a later time by a certain date.
I guess one of the concerns would be that if the state identified specific items that we would seek entry of, depending on the course of the trial and the questioning, there may be other items that have already been disclosed in discovery that may necessitate being entered in, would potentially not be part of this original witness exhibit list. Items that were in the discovery, but if that makes sense.
That does make sense.
Yeah.
And I understand what you're
Like,
saying.
I don't want her to say, oh, you can't use this because it wasn't on the exhibit list, which she will do. I don't want her to argue, I've never seen this before, it wasn't in discovery, which she will do. We'll do our best to create the exhibit list, but that doesn't mean something else might not pop up.
Okay. And that seems to be more of a fluid situation as to what may happen at trial, right?
Sure. I don't imagine the court's intent would be for the state to just produce the exact witness lists that have already been sent in discovery and just make a notation of every item of evidence. The idea would be to try to pare down.
That's exactly the idea. Now, obviously, that wouldn't
And again, we've heard them argue in cases. They gave us 1,000 documents when they're only going to use 100. Why can't they tell us what 100? The judge in this case is saying, just tell her what 100 you expect to use. You can say we might use more in the 1,000. Here's what we expect to use in the 100. Let's pare it down. Let's make it fair. Let's give her this opportunity. And again, things you would never hear in some other cases that you're hearing here. And there's more.
close you if something was produced in discovery and something that would not be relevant or admissible at a certain stage of the trial, but maybe later became relevant or admissible due to something that happened or something that was said. I would not foreclose the state, nor would I foreclose Ms. Boone from attempting to move that piece of evidence into evidence for the jury to consider. But it would be almost like a civil conference where you and opposing counsel would go over what your exhibits are prior to proceeding to trial. And I think that's important to do that so that Ms. Boone has the opportunity to view those in court, so that's on the record as to what she's reviewed, and then give her the opportunity to provide any objections, if any, to any of those exhibits. And again, I wouldn't foreclose you if you want to use items A, B, and C, and that's all you intend on using. I don't know what you intend on using. I don't know what evidence you have. If you only want to use and only show A, B, and C, but are saving D, E, and F for later, depending on what happens, I won't foreclose you from readdressing D, E, and F. But it's just an opportunity to address what it is you think you're going to be seeking into evidence at this time.
So essentially,
That's it.
so I think we could accommodate that if we could go around September the 1st. for that, and then that would give her an opportunity to review that USB and lodge any objections, and then we could potentially address those objections and go from there.
Okay, and that would be September 1 to have the evidence viewing, for lack of a better word, or for the list to be provided?
With a list of the USB.
Yeah, we're going to make this work for an October 7th trial date, Judge. I think September 1st is probably about the right time frame to have this in-court hearing to begin lodging those objections if she has any. My next question is, are you expecting the physical evidence to be brought here into court by a CSI so that she can potentially open it? Or are we just talking about digital evidence and giving her a list of the physical items?
So clearly all the evidence, right? Just like you would do if there was a defense lawyer, you got to bring all the evidence in. They're just confirming. I don't think they're trying to hide anything necessarily, but you're seeing how the state and the judge talk so much in a pro se case. And it's almost like the pro se defendant's not there because they're like, how do we do this to not screw it up? Because Teresa asked a great question. Is it possible she wins this on appeal because she was being forced to be pro se? I think that's her best argument. I don't necessarily know she would win on that. I don't think she would. I do think she's done more than your average defendant to constructively waive her right. But I do think that's going to be her number one argument because we don't know. It's a novel thing that doesn't happen a lot. Anna said she put a human being in a suitcase and suffocated him. How is she competent? So competency is a pretty low bar. It's not necessarily sane or normal or good. It just means competent, able to understand and prepare your defense and discuss your defense and aid in your defense. Kathy, do we know what her defense is as to why it happened? So we've heard different things, battered spouse syndrome, self-defense type of stuff, meaning she was so scared how he was going to act if she would have let him out, that he did it himself, that she left it open enough for him to get out, that she just passed out. Maybe she was drinking, maybe she wasn't, or drinking too much, I should say. Maybe she wasn't. Was it negligence? Is she going to argue for a lesser included? So we don't know specifically, but maybe we'll talk a little bit more about lesser included and stuff when we get to plea negotiations that may be happening soon.
If there's physical evidence that's sought, I want her to have the opportunity to review it.
And we should be looking at the top of the month for September so that we can get this done.
Okay, all right. Ma'am, do you understand that what it is that I'm discussing right now so that you have the opportunity to review the evidence that the state may be seeking in evidence in your trial?
Is it my understanding that they will supply me with a USB drive and then I am to review it while in court?
No, ma'am. So it's kind of a two-step process. So anything that's digital, that's not forensics or CSI or something that's tangible, will be provided to you on a USB drive. We also will have a hearing where all of the evidence, including any digital, electronic evidence, or any tangible evidence, CSI materials, will be shown to you in court, played to you in court, so you have the opportunity to review it here as well. Anything else will also be given to you on a thumb drive for you to review at your leisure based on the hours of 8 to 4 by the laptop at the Orange County Jail. And then we will have a deadline after we have this evidence viewing for you to identify in writing any objections that you have to any of the evidence that's been provided by the state.
So it's not a matter of any type of confidentiality. It is all done in the courtroom with everyone?
It would be in the courtroom, correct?
Are there going to be news cameras on top of it?
That's something I need to address. I do not want, because our jury pool is going to be coming from Orange County, I have concerns about the media's presence in the evidentiary viewing. So I may have to enter an order which would prohibit media access for the purposes of that hearing.
So I think that's interesting, right? It seems like he wants to keep the media out when necessary, but he wants to keep them in when necessary because he's trying to follow the law and do what's right, which we can always appreciate. But I also think he's trying to throw Sarah Boone a bone here and say, yes, I agree with you. At some point, we got to draw the line with the media, and the evidence viewing may be that line. But most importantly, he says, before I make that decision, I need to go do some research and make sure I make the right legal decision in this case.
Due to the nature of what is being produced and reviewed, so as to further prevent intimate details of the case being released prior to trying the case.
Understand that, Judge. Ms. Boone, not to turn the page completely, but I think it's pertinent to this discussion, has indicated through some counsel that had met with her recently that she wants to talk to the state out of the jail. And I was going to discuss that at the end, but perhaps to not waste the court's time, I don't know about bringing physical evidence out to the jail, but as far as the digital evidence, which will include autopsy photographs, which will include crime scene photographs, which will include videos, perhaps a different suggestion, especially since she has an investigator from Prison Break, is that we identify those files that we intend on introducing at trial so that they can review that digital evidence on their own in the jail, and we're not publishing all the digital evidence here in open court. That should allow her the opportunity to lodge any potential objections such as duplicative or
So she asked to meet with the state and talk with the state. Now's where we start to hear them talk about, did she tell other lawyers she wanted to talk plea deal? And if so, what could that look like? And if she was going to do that, why couldn't she work with a lawyer to get a plea deal done? We'll have more answers when we talk about this. Jermaine, sure. These are the type of situations where, pro se might have a better chance, not in Sarah Boone's situation.
Or any other objections she may want to raise about autopsy photos, so on and so forth, without exposing all of the digital media to the public. As far as the physical evidence, the state doesn't have any real concerns about the media covering that. She can open those exhibits, or somebody with scissors can open those exhibits for her if there are any exhibits she wishes open in the witness box where it's concealed from the media's eyes. So those are my suggestions, and then later we can turn to her request and put on the record how we would go about going out to the jail and meeting her.
The only concern that I have with that is I don't have a record as to what it is that she reviewed.
My suggestion would be that, because this is in the context of plea negotiations potentially, I would be out there, Mr. Cashore would be out.
That's the first time he says in the context of plea negotiations. Now, it could be real, or he could be doing it because of what's protected in plea negotiations, which we'll hear a little bit about in a second as well.
Out there, and our investigator would be out there, and we would record it. The conversation that we have, of course, and that would all be protected because it would be in the spirit of plea negotiations under the evidence code. And then we can all file in writing, the state can file in writing, these are the videos that we are going to use. These are the particular photograph numbers from the crime scene and from the autopsy photographs that we're going to use. And then we can have the defendant sign off on that as well, so that it's documented as to what was told that she would be facing at trial. And either she can review it with her investigator, or she can review it with us, being present, and then that way the digital evidence is not open.
Okay. Ms. Boone, what
So he said plea negotiations twice there, Teresa. And one of the reasons is because a lot of that's confidential. A lot of that can't be used against her later. So if she wants to speak more openly about her case and about things like that, maybe she'll be more open to talk about it, because that can't be used against her later if it's all in the spirit of plea negotiations. So is he using that just to have a conversation off the record with Sarah Boone? Or are there real plea negotiations? And if there are real plea negotiations, maybe it will be some kind of negligent accidental killing. Maybe they can agree to some lower amount of years. She's already been in prison for years. And maybe with good time served, she'll be able to get out early and it's not that long of a prison sentence. But she would have to agree to plead guilty to something. I highly doubt she's going to plead guilty to second degree or the top level crime that they're charging her with and going to trial on. But maybe she would plead to a lesser includer, involuntary manslaughter, something like that. No, a voluntary intoxication is not a defense for this crime in Florida. Lauren, what happens if she wants to testify in her case? So it's pretty simple. She basically takes the witness stand and starts talking. She tells her story. She says everything she wants to say. If she talks about hearsay, the state can object just as she gives a narrative, just like I'm sitting here. She would sit there and say, here's what happened. I woke up. We got a couple bottles of wine. We started playing hide and seek. I passed out. She could just tell the whole story. And then the state gets up to cross-examine her, and that's exactly the same, except that she can object while she's answering. Objection, judge, I think they're asking me blah, blah, blah. And the judge answers and tells her you either have to answer or you don't. So very interesting.
are your thoughts on that?
I'm a little lost. So an option of
She says, I'm a little lost, right? She wants to make clear that everybody knows she doesn't know what she's doing. And I think she would do that the entire trial in front of the jury.
reviewing what the state has with my investigator, and then be able to come with the objections and everything.
That's correct.
So I'm clear on having all of my evidence being in sealed bags, and for me to be able to inspect them to be here in the courtroom. I don't know how the attorneys have done any of this prior, but I don't believe that it was in the courtroom. So I'm just trying to protect myself against the media. I'm not sure at this point what is even suppressible that is available on the internet. But at the same time, though, it is my understanding that I should have some right to privacy in reviewing my the evidence. So I didn't know if my investigator and I are able to collaborate prior and view, and then come to court with everything finalized and ready to go with answers.
I'm certainly going to give you an opportunity to meet with your investigator to address it. The question is just the method of how to do it. The state's proposal is digital. They would meet with you, identify specifically digitally what videos, what photographs they intend on utilizing, and anything that may be physical, CSI, et cetera, would be addressed here in open court.
Just so the court and the defendant understands how physical evidence viewing would operate normally, we get a defense attorney and or her or his investigator would come out either to the sheriff's office or OPD's evidence center, whichever agency, and they come and view it. But it's done in the presence of the state, it's done in the presence of law enforcement, it's done in the presence of the CSI for the chain of custody. So attorneys don't get privacy when they're reviewing the physical evidence either. So that wouldn't really be any different than if she's doing it in the witness stand or wherever would be deemed suitable in court.
I think that's the most appropriate way to have the opportunity, ma'am, to review the evidence. I can't release that evidence to Mr. Lane to bring to the jail for your review because of the chain of custody issues concerning some of the physical evidence. So CSI would have to be here, just like an evidence viewing at the sheriff's office or elsewhere where counsel just identified. And I cannot bring you in.
They're like, this is how we do it in normal cases. The state's there when we exchange exhibits and evidence. We're both there talking about it, looking at it. It's not like a private situation, right? Which I understand that she doesn't get it, but it's not nefarious to have the state there when we're exchanging exhibits, right? You don't get to I don't get to take a firearm home in a criminal defense case that my client used, nor would I want to. You don't get to take physical evidence home. You don't get to do it like that. It's not like digital stuff you can just put on a flash drive, sure, but not the physical evidence they're going to present to the jury, whether it's drugs or the suitcase itself or her cell phone or whatever it may be.
Anywhere else other than here, and I can't release you to anywhere else. So I think the only solution that we have is to have the evidence viewing here with regard to any of the physical evidence.
Why is it that it can't be transferred anywhere other than here?
Because I cannot make a record anywhere else of what you saw or what was reviewed. The only opportunity for me to make that record is here.
And this is why crying wolf hurts. When you have a bunch of lawyers saying they review discovery with you, you say you've never seen anything, and then they show you your own handwriting on some of that discovery you said you've never seen, you start to lose credibility a little bit. And the judge is like, I got to be able to make a record of every single thing you see. Now, side note, this situation wouldn't change regardless of if she cried wolf or not. In my opinion, it would always be done like this.
Court.
What did prior attorneys do?
That was already identified by the state.
I know I'm trying to keep up with everything. What was the answer, please?
So an attorney who's doing an evidence view would come out to the law enforcement agency's evidence warehouse, for lack of a better term. And then in the presence of the state attorney, the CSI, and the lead detective, they look at the package. And if they deem any particular package worthy of opening and examining, they can do that. We can have the CSI bring butcher paper here so that any particular item can be opened, put on fresh butcher paper, and then changed out between exhibits so that there's no contamination. And then you can examine it. If Mr. Lane or any other representative from his organization is here, he will have the opportunity to photograph those exhibits once taken out of the packages. And that's essentially how an evidence viewing is conducted.
Thank you.
You're welcome.
So somebody said, do you think she's playing dumb? I don't think she's playing dumb, but I do think that anything that is even the least bit confusing or goes too quickly, she doesn't understand, she's going to make sure to make a point on the record. She does not want to be doing this herself. They're forcing her here. She can't keep up. It's so hard. She needs help. But I don't necessarily think it's playing dumb because there is going to be a lot of things she doesn't understand. Chain of custody in its simplest form is just this piece of evidence went from here to there, then from here to there. This person had it. They opened it. They closed it. Just so there's not like a spot where it's like, I have no idea where anything was or how it got here or how it got there or how we even documented it in the first place. Is the jury allowed to know why she's pro se? Thanks. No. They will just know she's representing herself. They won't know that she constructively waived her right to counsel by getting rid of every appointed lawyer that was appointed for her. Jenny, can she tell the jury she was forced to be pro se? No, that is not going to be a relevant thing. I will say, sometimes judges just kind of let pro se defendants say things, but the state will not be able to argue that. That's not going to be something that's announced to the jury. I bet she would take a deal if it meant she could get out with time served immediately. I bet she would too, but I highly doubt they're going to offer something like that.
And please, would the media be involved in that?
That's a conversation that I need to see if I can exclude them from participation or viewing that proceeding. There are rights where the media has to view proceedings in court, but due to the sensitive nature of what may be being discussed or viewed, I need to see if I can prevent media access. So without doing a little bit more further dive or research in that, I don't know if I can make that call at this time.
Yes, I have not heard of a case where the evidentiary hearing has been televised. So.
How many cases have you heard of, Ms. Boone? Like for her to say, I haven't heard of a case where that's happened yet. It's like, ma'am, I'm not trying to be rude, but do you really think you know all of the jurisprudence in Florida and what's happened in every case prior to yours? Like, come on, we're doing our best. The judge said he's going to research it. Let him go research it. Because if there is a case, he'll find it.
If you could please look into that, because I disagree with the media being involved in that.
I understand your position. And again, for the reasons that I stated earlier, I'm trying to prohibit as much as I can from dissemination to the public, especially some of the exhibits that the state may be seeking to utilize. We are going to go ahead and set the evidence hearing. The first is Sunday. September the 1st is a Sunday, and that is Labor Day. The court would be setting a hearing for Tuesday, the 3rd at 9 a.m. to have the physical examination here in court. At that time, in the USB drive or the, after our viewing here in court stays at your position to then have that meeting with Ms. Boone and her investigator and your investigator under the plea negotiations or settlement discussions auspices to review all the digital and identify what it is specifically.
You hear how they're saying that? It's like under the protections of plea negotiations and the confidentiality, you can review the exhibits together and talk through things. And again, they're bending over backwards. They're trying to help Sarah Boone. They're trying to make sure that she has the opportunity to view all this, but better yet, that they can document that she's reviewing all of this. And just think to yourself here, okay? Because we've watched a lot of cases together, reviewed a lot of cases together. Could you ever imagine, like the state is about to recommend a cell phone digital forensic expert to Sarah Boone? Like, hey, here's one a lot of the defendants use. A, do you really want the expert recommended by the state? Number one. Number two, could you ever imagine Thompson in Brian Koberger's case recommending an expert to Ann Taylor? And do you think Ann Taylor would use it? And better yet, do you think Thompson would have recommended the, star witness of their other hearing, those experts that Taylor has called, that have put Thompson up on the screen saying, you poisoned the jury pool with your press conferences and telling them to go look at the PC affidavit? Do you think the state would have recommended those experts? But that's what's happening in this case. It's like me going in arm wrestling my 8-year-old son and telling him all the best techniques and the best way to win. And, maybe start early. And here's how you might be able to win, knowing full well I'm going to win.
We are happy to defer to the defendant's wishes on that. And I want to have that discussion. It seems like we're turning that discussion. So I'll leave it in Ms. Boone's court. My indication from one of the attorneys that she had discussed things with said that she wanted to have a conversation with us. And so I'm offering that up. In the past, with female defendants at the Orange County Jail, there are classrooms, or at least one classroom there, where we could arrange to meet. It would be a big enough room for 4 or 5 of us that would need to be there. And then we can discuss that, whatever it is she wants to discuss, and it would be recorded. And again, those portions of the conversation that are about plea negotiations and the evidence and whatnot in the trial, I believe under the evidence code would not be admissible to be used against her. And I believe it's her when she wants that to happen. We can make arrangements to try and accommodate that. It should not take us very long at this point, given the age of this case, to select and identify which digital evidence exhibits we're going to use. It's simply a matter of getting rid of duplicative and irrelevant photographs from the scene and autopsy. And I believe the videos won't be too hard to decide which ones to use. I don't know that there's a whole lot of other digital evidence.
Okay, all right, ma'am, do you have a thought on when you would like this viewing to take place at one of the classrooms at the Orange County Jail under the concept as identified by the state?
So this meeting is separate. This is prior before everything else.
What I would envision, to not waste anybody's time, is we can go out there and have this discussion. If there is a discussion we had about plea offers, one of the other topics was other matters, so that's kind of ambiguous. I'm not sure what other matters are. And then also we can let her know and probably provide the court in writing a list of the digital evidence that we seek to introduce. And then that way, if she wants us to review those digital evidence items together with her in the presence of everybody, we can do that. Or we can let her, with the list of the digital evidence that we plan on introducing, review that as many times as she wants by herself and or with Mr. Lane.
I understand. So would I be leaving with the digital evidence today, or how soon may I receive that?
So the state needs to assemble that. So my thought would be to have that meeting, ma'am, on the 3rd of September. So we would have a hearing at 9 o'clock in the morning where the physical evidence would be reviewed here in the courtroom. As soon as that evidence was finalized and reviewed, the state with their investigator, yourself with your investigator, would then meet that afternoon at the Orange County Jail to address, as the state has identified or spoken about, any settlement negotiations, plea offers, and under the other category to address what the digital exhibits are. They would provide you those on a USB drive, and they would identify for them specifically what it is that they are seeking for you to review at that point in time and have the ability to review it afterwards.
We're happy to do that beforehand, and I just want clarification. By providing her the USB with all the narrowed down exhibits out of discovery, are we providing it to Mr. Lane? How are we physically?
It would have to be provided to Mr. Lane, who would then have to provide it to a member of the staff at the jail, the names of which I have from the captain at the jail as to what persons are involved in the laptop process. And then once that's done, I would require Mr. Lane to identify with a filing in the court, probably in the form of an affidavit, as to when, where, and how the USB drive was received by him, and when, where, how, and to whom it was delivered.
Thank you.
So they're going over some of the logistics at the jail with the computer and who has access to it and how it's getting to her. Mary said, are you still planning on attending for a day? Yes, I am still planning on that. If there is a trial, maybe if she takes a plea deal, I'll go to sentencing or something. We'll try to figure something out that I can work into my schedule for sure. Jilly May, I wonder if she had any response whatsoever to her attorneys wanted ad. I think you'd be surprised, but no comment on that. No comment on that, number one. But number two, I do kind of wish a little bit if there was a perfect world where maybe a prior judge could have thrown her into this deep end after lawyer number 2 or 3 and then said, okay, we'll give you one more chance once she's seen what it's like to do it herself. And then maybe she would have been more respectful with that lawyer, but it's not really how it works. So once you waive your right to counsel, you waive your right to counsel. Terry, hi again. Terry from England, paralegal. I can't honestly help but deduce that defendant Sarah Boone was simply taken over by alcohol and ticked off with the situation, went to bed and forgot the entire ordeal. Great channel, by the way, Peter. Yeah, I think that's a plausible explanation, Terry. I really do. And I think it should be some kind of negligent killing personally. But I don't know how she's going to explain it and how she's going to explain her interrogation the next day and what she said about it. We went through the interrogation in depth in multiple parts. If you guys want to watch that, it's on our YouTube channel on that playlist. All the things she said there are contradicted. She tells lies, all sorts of things that I think are going to come back to bite her in this trial.
I feel uncomfortable with you all applying my evidence to the jail. So I don't know if there's a way that, I don't know if you're aware, but my jail phone calls have been released, and there's a lot of things that have been released from the jail. So I don't know, I do not feel protected by you all handing it to the jail. I know that Jillian and I previously had worked on the laptop with USB drives that he has furnished himself from bringing in from the outside. So I didn't know, and I was more comfortable that there was a process or procedure. I don't know who your names are from the jail. I do know the captain whom I spoke to the other day regarding my laptop. But I would very much.
Who was that, ma'am?
I'm sorry?
Who was that?
Woolwich.
The captain that you spoke to, who was it?
D. Giovanni.
Okay.
There's multiple sergeants involved, and I did get a gentleman who was supposed to be here today to pick up USB drives. So I don't feel comfortable, please, with providing the USB drive of my evidence or things that have been leaked or released from the jail. So if there's a possibility, please, I would like for my investigators to have that and bring it with me prior.
If I understand the jail's protocol, which I read to you at our last hearing, the jail will keep custody of the USB drives and release them with the laptop as well. So I don't know how I can bypass that process that they've created, because the USB drives and the laptop, when it's checked out by you and when it's returned by you, is all going to be logged in their IMS system.
Right, it's simply a laptop. It's a very basic laptop where anyone affiliated with my case has the type of digital evidence they bring in with them from the outside. It's simply a basic laptop that we are able to utilize at the Orange County Corrections Department. That's how we have done that prior. So I don't know what it is different. I don't know the jail protocol because no one's included me.
You were provided a copy of it through the court filing, and I read it to you at the last hearing.
She's like, I didn't get that. He's like, ma'am, I read it to you. You definitely did get it. And again, that's crying wolf, and she's just done it too much. Bodie said, Peter, the judge said standby counsel isn't involved until the defendant says they don't want to be pro se anymore. So yeah, but standby counsel is involved when a defendant waives their right to counsel, not loses their right. So that's the difference. Like if you waive it, the judge's like, okay, we're going to put a standby counsel here in case you change your mind. She has not made the decision, so therefore she can't change her mind. Standby counsel, he's saying, doesn't come into play in a situation like this, which is very rare, unusual, not great, not what we want, but she has put herself in that position. So standby counsel, he said, is not appropriate for this situation because she did not choose to waive there, so therefore she can't choose to go back on it.
Understanding is different than my understanding because my contact from the jail telling me something different.
Who? What are their names?
There's multiple sergeants.
What are their names?
I'd rather not get involved with their harassment or anything from other.
Ma'am, I'm referring to what the Orange County Jail and the captain that you identified specifically as to her memorandum to the court, which was read to you at our last hearing, which was sent a copy to you by notice of service, and it was provided by U.S. mail. It was sent out last week.
I didn't get to receive anything such as.
Don't worry, I have a copy to give to you this morning, just in case you have not received it.
Yes, the last thing I have is your order that you provided me with the implementation of your USB drive.
Okay. All right.
So anything that you were speaking of in the meantime, I do not know, and it was served by process,
It was served by U.S. mail.
by U.S. mail?
Mhm.
Yes. I actually have 3 motions, if I may, submit them to you.
In a moment.
Yes, in the process of, because the address which you are, I'm guessing, sending these to is incorrect.
I received your letter addressing the address issue. That's been remedied. So the appropriate legal mail address will be utilized. It was simply a clerical error, and that has been remedied. But regardless, I did read to you at our last hearing the protocol for the USB drive in the jail. The court is inclined to follow the Orange County Jail's protocol with regard to the USB drives. So the evidence, digital evidence that the state seeks to admit at trial will be put on a USB drive, delivered to Mr. Lane. That will be delivered to a representative from the Orange County Jail. and Mr. Lane will thereafter file a filing with the court in the form of an affidavit identifying when he received it from the state and who he gave it to, when he gave
Still hasn't gotten it yet, which I found interesting.
it to, and what representative of the jail he gave it to.
So it goes from the state to Mr. Lane to the jail.
For the purposes of indexing it, for the purposes of their records under the protocol, and then it will be available for your use.
So if I want to see all of my evidence digitally, I need to contact someone at the jail.
No, ma'am. The evidence that were in the two bankers box that Mr. Lane digitized for you is going to be provided to the jail. That's going to be provided with a laptop to you. And that's available to you from 8 a.m. to 4 p.m. every day in the protocol that I read to you at our last hearing.
Yes, and I will speak to the captain just to be aware that everyone that it is in the process, because I do not feel comfortable with any of this, and I do not feel protected either by the courts or the jail system. So
She doesn't feel protected. Things get leaked. The media is there. You're seeing a similar or a common theme throughout a lot of her objections and problems.
for right now, I don't know if it can be postponed or if it's something that I need to write another letter to. Everything takes longer in jail. So by me trying to get a hold of the captain nonetheless is going to be a feat in itself. So I want you to know if anything that I am in the process of trying to reach out to the captain. I don't know if she'll be here today or if it'll be the contact person. So in the process, I am working on speaking to the captain because I do not feel, like I said, that I'm protected in any way, shape, or form by the Orange County Corrections Department with withholding my evidence in any way, shape, or form.
Okay. The court's going to follow the procedure as I outlined at the last hearing.
You notice he just sits there quietly, lets her make her entire piece, and then gives his decision. And she doesn't really change his decision ever.
So here's what we will do. We will, on Thursday, September the 3rd at 9 a.m., we'll have a hearing to review the physical evidence. At that time, the state will provide its exhibit list, which will be filed with the court at that time, and a copy will be given to Ms. Boone of the physical and the digital evidence they are seeking to admit. After we have the in-court examination of the physical evidence, that afternoon, there will be a meeting at the Orange County Jail between the state, its investigator, Mr. Lane, Ms. Boone. Sure, if you all want to meet in advance of
We're
that
just kind of recapping what they're going to do. We're going to skip ahead a little bit.
evidence, the court would then, like I said, thoughts would be to give you 2 weeks until the 17th to lodge your objections. And those would need to be provided in writing by the 17th. So that if there are objections and if we need to have a hearing on them, that hearing can be held when we have our pretrial on the 26th. That would give the state ample opportunity to prepare for any of the objections that you have.
Forgive me, and thank you for your patience, everyone. So on September 3rd, I will be viewing the digital and physical evidence here in the courtroom.
Correct.
And then later that afternoon, I will be meeting with the state and my investigator.
If they don't meet with you prior to that date, if they meet you in advance of that date, they can do so.
Yes, Dave. If I may ask, please, what's your name, sir?
William J.
Could you spell your last name, please?
J.Y. Don't get asked that one.
And what is your affiliation with the state?
I'm homicide unit chief.
Yes, please. And I am okay if you would like to meet prior, so my time is consumed on the day of our meeting, supposedly on the 3rd.
So I assume you have availability. Should I meet with Mr. Lane to discuss his availability so we can get out there this month?
Yes.
That you can do that. And like I said, Mr. J, if you could file that notice, just identify when, that would be most appreciative. So ma'am, understanding where we are with the viewing, what is September 17th for the deadline for your objections acceptable to you?
Yes, and if I may please raise the point that I have a motion here in regards to one of the process of looking at for the laptop. I do not have my discovery as of yet, and I do not have a laptop as of yet. I do not know what hiccups may be involved. There's a lot of hiccups.
It is starting to get, I mean, when people put pressure on the court system, and we talk about this in other cases like Koberger, it's like things can really feel delayed. Like, why doesn't she have it yet? It shouldn't be that hard. The state's had this stuff for years. How hard is it to get her a laptop? Like, she should have it by now, and she doesn't. And you better believe she's going to sound the alarms every day that there's a delay. Diva Dawn said, first live, obsessed with this case. I don't know if you've addressed this yet. Do you think they'll put the ex on the stand to testify about her abusive tendencies? I think it depends on her arguments. It depends on what her defense is. If she goes with the battered spouse defense or some kind of personal, self-defense, then yes, I do think they'll bring up those tendencies for sure and her actions in the past. If she goes like for accidental or things like that, then maybe not. Maybe it's not relevant. But depending on what her defense is, yes, I think that's a very real possibility.
The jail already. So I'm trying to figure out when and where I'll be able to review anything. So there's a rate restriction also that is being put on the laptop usage from 8 to 4. I'm unable to utilize my time to the full extent. Also, I have a motion here to receive my hard copy evidence because when the laptops are in quotes, the laptops in quotes closed for the day at 4 p.m., I can therefore pick up using the hard copy evidence.
I haven't had the opportunity to review the motions that you're speaking of. Neither has the state. We'll address them today. I don't have a problem doing that. I'm just not going to do it right this second because I haven't had the opportunity to review them yet.
Yes, and I'm just explaining myself in the meantime, please, so you are aware of what I have already thought of and am trying to ease the pain of everyone with me trying to figure out how to do everything and when and do it appropriately. But I just wanted you to know that by agreeing, I have that to also be looked over.
Okay.
Please. 9/17, if that has to be changed, am I okay to do that?
I'm trying to set deadlines now, ma'am. And it will give you 2 weeks to revise.
This is just for the evidence?
Correct. This is only addressing any objections to the evidence that the state seeks to admit.
The digital discovery, is any of that included in that?
Yes.
Okay. I'm very weird to think because of deadline.
But we're setting them today,
I understand. So the third is a what day? Thursday?
Tuesday. So the 17th will be 2 weeks later, Tuesday the 17th.
And that is me coming with my objection.
That will be you filing your objections in writing with the court. And to the extent we would need to have a hearing on those objections, we would have them when the pretrial or trial case management conference is set at 9 a.m. the following Thursday, the 26th of September.
I'm sorry, what is on the 26th?
That's when we're having our pretrial or trial case management to address any last minute issues regarding trial.
Forgive me. So today being August 5th, I'm supposed to expeditiously complete my case that in every way, shape, and form by September 26th in order to go to trial for October 7th.
The dates are what the dates are. September 26th is
She's like, I'm supposed to do this all from October 6th, and she ain't wrong, right? She doesn't even have the discovery yet. Now, she's in a little bit of a different position than a new lawyer coming on that doesn't know anything about the case. She knows everything about the case. She doesn't know the discovery. They need to get that to her. These delays are not good. And like I said before, I would have kicked it to December myself personally. I'm not the judge. I'm not a judge. But I would have given her a little bit more time and been like, this is it. This is the last continuance, no matter what. I don't want to hear about anything else. But I mean, this is quite a feat here. She's got 6 weeks to prepare her entire defense and go over everything the state has and all of her objections, because September 26th pretrial, she's got to be ready to go basically right then.
the trial case management date. October 7th is the trial date.
So by me not even seeing my discovery yet 2 days and only being restricted to a laptop from 8 to 4 and not having my hard copy evidence.
You have 62 days to prepare for trial, not including today. And you're going to get your discovery today.
Wow. So in over 4 years, it comes down to me representing my.
She's like, he said, you're going to get your discovery today. And of course, she has a snarky response.
Wow. So in over 4 years, it comes down to me representing myself in 62 days.
I'm not going to answer that question.
Over 4 years, and it comes down to me representing myself in 62 days. Sounds like she's making an appellate argument, if you ask me.
And I said, this is
What now we're addressing, ma'am, is September 17th,
right.
the deadline, which is 2 weeks after having the physical view of any of the physical evidence. It sounds like Mr. J is going to try to meet with you pretty promptly regarding the digital evidence. So you'll have plenty of time to review that in 2 weeks at a minimum, or 2 weeks at most, rather, to lodge any objections to the physical evidence.
I understand. I just don't understand how to file objections.
I cannot answer that for you. That would be me providing you legal advice, which I'm prohibited from doing. All I can tell you is that if you have objections to any of the exhibits that the state may seek to move into evidence, you will have to lodge those objections by the close of business on September 17th. And those objections will have to be in writing. If we have to have a hearing on those objections, that hearing will be held on September 26th.
Okay.
And there's a million easy ways she can do her objections, but again, he can't tell her. I think standby counsel would be appropriate to answer those kinds of questions, but again, I'm sure she would use it more than that, and that's not really what standby counsel is. That's like somebody helping a pro se defendant, which maybe is not even appropriate. Jenny, I think she should absolutely be uncuffed, maybe keep her feet shackled so she doesn't run or do anything like that, but to be able to write and represent yourself, I absolutely think she should be uncuffed.
If I may ask, are these being delegated or I'm being incorporated in this in order for me to be able to say yea or nay?
I don't know what that means. What do you mean delegated?
Are you delegating to me as you delegated everything else in regards to taking my counsel and all of your orders?
You are representing yourself for the reasons that the court identified in its 16-page order. It is your responsibility, as you are representing yourself and proceeding pro se, to comply with the court's orders and deadlines. So if you have objections to any of the exhibits that the state may be seeking to offer into evidence, be it digital or physical, based on your review of those, the deadline to submit those in writing would be on September 17th.
Okay, so you're making statements, so I don't have any say in it.
I've asked you what your thoughts would be as to when. You've never provided me in a disagreement with regard to that date as of yet. You've asked questions about your motions that I haven't seen yet, your desire to have hard copies, which we addressed at the last hearing, but I'll be glad to address it again today.
I am pro se and have never been pro se before and do not know what I'm doing. So I just want to make sure that I do it correctly and have an understanding also if you are proposing that I go to trial within 62 days, that I know what I'm going into and what I may expect. So I didn't know if this would just be easier on everyone else, if they just delegated the dates and gave me a printed copy with the order, whatever information you have. I don't know. I don't know either if you all are just proposing that because I'm incarcerated, just the dates are what you tell me. I don't know what I'm doing. I do not know what I'm doing. So I'm trying to learn as I go, which is why I'm grateful for everyone's patience. But at the same time, though, for me to accept this date and then not be able to meet it, what happens when that happens, and if she happens?
I can't answer that question. Again, that would be me providing you legal advice as to what to do if something happens.
If she was a lawyer, what she would say is, I object to this date. I think this date should be pushed out. I want to continue the trial. So put it on the record. The judge will deny it, but at least you put it on the record and you asked. So you're protecting it for appeal, but she doesn't know to do that. But that's kind of what she's asking is, I want to object. I want to ask for a continuance. You can deny it on the record, but at least it's protected for appeal because there's no way I can prepare this case myself in 62 days.
I simply cannot answer that question. I'm not allowed to.
Okay. Well, I'm with the court, so whatever it is that you all are trying to do in order to expedite this even more than what it's being expedited, I'm guessing I agree with September 17th.
Okay. All right. I mean, I believe that takes care of all of the deadlines with regard to the state's exhibits. Now I want to address deadlines for any exhibits or witnesses that you may be seeking. I am mindful that you will be receiving the discovery today and that you have not had the opportunity to review some of the items that may be in the discovery. So how much time would you like to provide to the court the list of exhibits that you may be seeking to enter and the list of witnesses that you may be seeking to have testified in a defense should you choose to put one on?
Please understand that I do not have access to a normal phone. I don't have access to a normal phone at normal hours. So I am trying to overcome the hurdle of trying to, number one, locate any of my witnesses, and then also try to communicate.
So she hasn't had 4 years with all the documents that the state has with the cell phone download. We don't know what she has seen and what she hasn't seen. And I'll just say 60 days is short. I'm saying that's what she should do to protect the record. I'm not saying she deserves a continuance. I said I would give her one till December. 120 days is also not a long time to prepare for trial, but it's better. It's more fair. You're showing the appellate court that you at least did something. I think this court has appropriately documented the record. I don't think he's done anything wrong. I'm just saying this is what she should do if she knew how to represent herself, which of course she doesn't. That's why you shouldn't represent yourself.
Then a payphone only telephone call that I do not have regular access to, and that limits to only 15 minutes that I have to share with 62 other inmates. That is a hurdle plea that I need to please take into consideration in order for me to be able to try to determine my witnesses, to determine any expert witnesses. May I ask, does the laptop have internet access?
I'm unaware. I'm unaware if it does.
To view any documents?
I'm unaware. I can't answer the question that I don't have an answer to. I'm unaware if it has internet access.
Whom is it I need to speak to in order for this?
We may be.
I think she should get internet access. Obviously, it's going to have to be monitored, and people are going to have to know what she's searching and what she's doing. It shouldn't be unfettered. And there are different ways to do that where you can keep it confidential, but also make sure she's not doing anything inappropriate on there. But again, if we want to give people really some kind of chance, internet access would help.
To inquire of the jail representative who is appearing for the
And
hearing.
I understand people are saying you're a softie, which I get it. I get it. What I'm trying to do is just protect people's rights. I feel very confident she's going to lose this trial. I just don't want to railroad anybody, even Sarah Boone. I think she's made a lot of bad decisions. She's put herself in this position. So I get why the judge is doing it. I'm totally fine with it. I think it's totally appropriate. I just always want to give people the benefit of the doubt. I want to make sure it's as fair as possible. So when they go and lose, that I feel confident and secure with a just and fair verdict. That's it. And I get it. I get it. If you want to call me a softie, I understand. Listen, I don't think you should go soft. If she gets convicted, hammer her. Like, she did this, she gets convicted, and a jury finds her guilty, go for it. But in this part of the process, people are presumed innocent. I always will give them the benefit of the doubt and maybe be a little softer than I should when they're here, sitting here, presumed innocent.
Hearing this morning, and if not, the captain may be able to provide that information, but I do not know if it has internet access.
May I ask your contact names from the jail?
Give us 1 second.
Please, and also because of the court error of sending my information that you're referencing to the incorrect address, could you please provide me a copy of that also?
What is already printed out of the protocol, we will have the deputy hand deliver that to you. Do you feel comfortable in providing the court and the state the list of your witnesses and your exhibits that you may be seeking to introduce?
I'm going to go with to be determined because I just explained also, please, that I do not have access to a regular phone. I need to locate anyone. I need to do research. I don't know if I have internet access to anyone. I don't have a phone book. there's no way that I know how to do any of this without essentials and fundamental equipment in order for me to be able to provide you with those answers. I cannot promise anything because I do not know how I would be able to do any of that at this moment. I would like.
By the way, you take a computer and internet and all this stuff away from a lawyer, they'd be like, I can't tell you when I'm going to have witnesses for you, judge. So I get it. The difference is we don't put ourselves in those positions like she did. This is why you don't want to represent yourself. But it's kind of like both things can be true. It's a paradox. It's like she can't do this and she's right, but she can't do it because of her own actions and decisions. So that's why a judge's job becomes difficult in this situation when it's a pro se defendant. SM, hi, Peter. Just getting into this case. I've read what she's accused of in the video, but I feel kind of bad for her watching this. What's the issue with all the lawyers she went through? So we've done about 20 videos on it. I really hope you can go back and watch them and leave comments on them of what you think as you go through. I don't have time today to break down what happened with all 9 lawyers, but some were her fault, some were not. So I encourage you to go back and look through some of the ones where I go through in detail. There was a letter, I don't remember what video it is specifically, where she talks about all the lawyers prior to this one. I think it was either lawyer number 7 or 8 that we did that one on. So I encourage you to check that out. There's a lot going on in this case.
To propose your understanding of a meeting that I would like to have with the captain, so I can see if I can have access to a regular phone, if I can have access to an internet. Right now, I have a tablet that is used for text messaging and movies and the law library that I utilize. I don't have access to the phone. I don't have access to the internet.
You can certainly have those conversations with the jail representatives. But ma'am, we were on notice today to address those deadlines, and I cannot set a to be determined deadline at this time. I understand that there's been some delays with regard to discovery. As I told you at the last hearing, we're moving as expeditiously as possible to get you that, and it took some time for that process to be created. That process is going to start today. Mr. Lane's here. Representative from the Orange County Jail will be here. That handoff will take place. You'll have access to that laptop with all the information today.
I got to be honest, if I was the defense attorney in this case, my question to the judge was, I'm still not clear on why it didn't happen before today, and we would like to continue the case because of it, right? Like that is what I would be arguing. That is what I'd be arguing. So Edward said she's done for going pro se. She didn't do it on her own. She didn't want to. Peter, when you see people in this situation, do you feel like you want to help them in general? Just curious. Yes. Yes, generally I do. I know obviously it's impossible for me to help everybody and just kind of go through. And that's why we have to pick and choose who our clients are, who our clients are not going to be. So it doesn't work out to be able to help everyone. But yes, I hate to see people. It's like one of the reasons I wanted to become a lawyer and like it so much is helping people who can't help themselves, who don't know how to help themselves, who are in situations they don't know how to deal with. That's what I love coming in and helping people with. I feel like that's my calling. When it comes to this, there's not a ton I know how to do that other people don't know how to do. I'm not handy. I'm not the smartest guy in the world. I'm not the best at a lot of things, but I do really like that and enjoy that. And it's one of the best parts of the job. But on the flip side, you can't help everybody. And that's a struggle as well.
Defendant's not going to make a suggestion to make a state.
Sure.
My suggestion would be to give her 14 days after the point that the specific evidence identified by the state to use at trial is provided to her. So, for example, the physical evidence, which we plan on giving her the list of those physical items well in advance of September 3rd. That will just be the date that she can actually see them. But my suggestion for those physical evidence items would be September 17th, and then 14 or 15 days after whichever day we get the specific list of digital evidence items to her would be our suggestion.
Okay. Ma'am, are you amenable to that? 14 days after you've had the opportunity to review the digital evidence and 14 days after you've reviewed the physical evidence to provide your exhibit lists?
I don't feel comfortable with any of this. I don't have the same opportunities as the state or any attorneys prior. So I feel it's a lot of pressure on me and forcing me into these things which I may not be able to meet or exceed.
Can I add that obviously either side, if there's good cause for why a deadline wasn't met, if something comes up, then we're not prohibited either side from complying with the rules of discovery afterwards.
He's saying like, if you don't get it to me in time, I'm not going to object. Just get it to me before the trial and we'll be fine as long as good cause is shown. And if you say because I'm a pro se defendant in jail trying to represent myself, that's pretty good cause for a delay.
But there would just need to be a cause shown at that point.
Do you understand that, ma'am?
I do.
That I'm setting these dates for now, and if either party can establish good cause why these dates should be moved.
Yes, and that is why I'm trying to make everyone aware prior to all of this to understand my circumstances by being incarcerated and not having access to a phone, not having access to the internet, and not having access to any more other, like I said, basics, fundamental basics, which is why I'm making you all aware now, so you are aware that when the time comes, should it, why for good cause, I'm saying my good cause is now, if not there are additional at that time.
Ma'am, as of right now, the court is inclined to agree with the state's suggestion that 14 days after viewing the digital evidence, which will take place no later than September 3rd, sounds like it'll take place way in advance of that, you were to provide in writing your list of exhibits that you want to attempt to move into evidence. 14 days after viewing the physical evidence on September 3rd, you are to provide in writing the list of any exhibits that may be physical that you intend to enter into evidence. Those dates can be extended for good cause that may be shown. State, would you like the opportunity to review those exhibits similar to evidence viewing that we're having with Ms. Boone reviewing the state's exhibits? Would you like a similar opportunity to review any of her exhibits?
If the defense has any physical evidence to place in evidence, I can make those arrangements with Mr.
Okay, all right. I will set a deadline for the review of September 26th.
Is the review that you're taking at least for my exhibit and witness list?
That is correct. Witness lists for the defense and Mr.
She should have the witness list and the discovery that's being provided as far as the order and the list of witnesses that we're going to call at trial. We will get that ahead of 9/3.
Okay, all right. So the deadline for the state's production of the witness list will be September 3, no later than, and September 17th for Ms. Boone. Ma'am, similar to the objections to any discovery, that'll have to be in writing as to who it is that you may be calling as a defense witness. You'll have to provide that to the court in writing by September 17th.
Yes. And if I may ask, please, what you're typing, is that for an order or for today's proceeding?
It is for an order which you will be given a copy of. It may not be able to be hand delivered to you, ma'am, because I'm going to have to move some stuff around based on my scratch notes here, but at a minimum, it will be mailed to your proper address. Due to that clerical error, that will not be an issue.
Wonderful, thank you.
Okay, I think that addresses all the issues with state that you believe we need to address from a scheduling concept.
We're good with scheduling concept.
Other than what I have been done to court, I do not.
Okay. Bruce, can you see if Mr. Sergeant Case is here? You can raise your right hand, Madam Clerk, and state your name for the record.
I'm over transportation, downtown port holding, BRC ports, medical security, and the juvenile assessment center.
Okay. Are you aware of the protocol that Captain DiGiovanni created with regard to Ms. Boone's use of the laptop?
I am.
Okay, all right. Have you had the opportunity to review that protocol?
I have.
Okay. Mr. Lane, can you come up here, please, sir? Your right hand, Madam Clerk, state your name for the record for me.
Billy Lane,
And what's your affiliation with Prison Break Investigations?
I'm the owner and chief investigator.
All right, sir. Last time I saw you, I had tasked you with digitizing 2 banker's boxes of information, and you said that you would endeavor to accomplish that task by today, understanding that you were out of town for your son's wedding. He'll get a great time. Were you able to fulfill that task, sir?
Yes, sir.
Okay. How many jump drives or drives do you have?
Of the digitized information, there's one of those, this drive here is a copy of all digital discovery that I have in my possession. Ms. Boone would of course needs if they wish to facilitate that through figure it'd be easier to facilitate it now through the jail than me trying to bring it in myself.
That's exactly my thought. So you've shown me, sir, a small thumb-sized USB jump drive. That USB jump drive is the information that's contained in the 2 banker's boxes, correct? And the other jump drive that was the larger of the 2, that jump drive is any digital information that you had previously by virtue of being the investigator.
Yes, sir.
Okay, all right. The record's going to reflect that information is going to be hand-delivered by Mr. Lane to Sergeant Casey. So Sergeant Casey, you please take custody of those 2 thumb drives.
And this is, chain of custody. This is putting everything on the record. This is making sure Sarah Boone can't say she wasn't given it. That's kind of this whole charade you're seeing here. I don't want to call it a charade, but that's why they're doing it in open court in front of the cameras on the record. So everybody can see we're treating her fairly and here she's getting it. Diva, would you give the continuance that are specifically asking for it? I probably would. Also, isn't standby counsel supposed to guide her a little bit? Maybe a little bit, but they're not supposed to be like her co-counsel or assistant counsel. Linda, how would you help this Sarah Peter? Well, again, there's not a ton. I just mean like to explain things to her and say, this is how it works. This is what you can do. It's not a case I would want to take on its own, to be honest. But I would just want to make sure she understands what her rights are and what the best moves are. And once you start getting in that vortex, it's hard to get out. Has she been offered a plea deal? Fishy colors? I would say probably, but I don't know. There's no way for me to know. Jake, is it more likely the state will offer a plea the longer this goes as potential appellate issues accrue over time? Potentially. That can be one of the considerations when the state offers a plea deal. Sarah, this is a dumb question, but could she appeal and argue ineffective assistance of counsel referencing herself? Probably not. I'm just curious. It wouldn't be ineffective assistance of counsel. It would be an inappropriate waiver of her constitutional right, that the judge did not allow her to exercise her constitutional right to counsel. That would be her best appellate argument. If this were to go to appeal, would she be provided with an appellate attorney? So yes, she would be appointed appellate counsel. I don't think they would say she's waived that right. So she would get a chance with that. SoCo Judy, you're a great pickleball player. Thank you, SoCo Judy. This is the comment I needed today.
I ask you, sir, to comply with the terms of the protocol, to have those added to the laptop. It'd be available for Ms. Boone's use today once she's returned to the Orange County Jail. Do you have any questions for Mr. Casey?
No.
Okay, sir, thank you very much. If you can proceed with that task, I appreciate you. Thank you. Mr. Lane, you took custody with you, sir, as well. Well, before you leave, Sergeant Casey, state, do you have any questions for him?
No.
All right, ma'am, do you have any questions for Sergeant Casey regarding his compliance with protocols provided to be by the captain of jail?
Mr. Casey, could you please make note to Captain DiGiovanni that if she has time at some point, as soon as possible, to please sit down with me for about half an hour to go over quite a few things that I need to have resolved?
I'll inform her.
Please, in regards to the laptop.
Okay.
Thank you.
Thank you very much, sir. Mr. Lane, when we were last here, you also had 2 banker's boxes. Did you bring those back with you, sir? Okay, could you bring those back up? Clerk take possession of what was pre-marked as A and B for the purposes of the June 28th hearing, and we'll hold those into evidence. Do you have any questions, Mr. J, for the investigator with regard to his task?
No, thank you.
All right, ma'am, do you have any questions with regard to your investigator regarding his completion of the digitization process?
And finally, my question is, Mr. Lane, do you know when you would be coming to meet with me at the jail?
It's going to be my intent to try to get out there at the end of the week or beginning of next week.
Thank you.
Thank you, sir. I appreciate you.
One housekeeping thing.
Yes, sir.
I don't know if Mr. Lake, since he's here, would like you to sign my invoice or have Ms. Boone do it since she's pro se.
Email back later.
Would that change the original, the
He's
5,005?
just basically asking how he gets paid.
What is his name, please?
That's Christian Lake. He is an attorney associated with the JAC, the Judicial Administrative Commission, regarding costs for indigent defendants. All right, state, from a scheduling perspective or the protocol, which I filed a notice of filing, I'm sure you've had the opportunity to review it. Anything else we need to address from that?
We're good on scheduling, Your Honor.
Okay, thank you. Ma'am, anything else we need to address regarding scheduling or the protocol other than what you've already addressed this morning?
Will my investigator be present at anything for and with me?
I can't speak to for or anything, but based on what we discussed today, your investigator will be there for the digital review, which will take place no later than.
Feels like she's starting to try to treat and feel like her investigator is her lawyer at this point, but get it. She feels alone in a situation she doesn't know what to do. So, I mean, there's no great answer or anywhere great to turn.
September 3rd.
Okay, yes, I would like to have some type of like this.
You will be there. You will be there. Mr. J is going to be recording the conversation as he identified previously.
Thank you.
Now, ma'am, you made reference to some motions that you may have brought with you this morning. All right, if you could hand those to the deputy. We'll get that to you.
Provide me with, which I believe was a memorandum for today's date.
I haven't, is she being who, the captain?
No, I'm not sure the name.
Oh, Madam Clerk, no, the only thing she's printed out for you right now, ma'am, is that protocol. I'm going to be finalizing the order. And like I said, I may be able to finish it before we're done with the hearing, and I'll hand deliver it to you. If I cannot, it'll be mailed to you.
And yes, I understand. It was regards to another document proposing the dates for today's hearing. And I guess it's some type of notice. That's what brief that she was going to print out to give to me, so I have that.
Okay. Mary.
I did not receive that, nor did I receive this protocol list.
That's two. Everything that's been discussed. Can you print it out? It should be in the file. All right, ma'am, let me take a moment to review your motions. Give me a moment here.
Thank you.
We're going to skip this part, obviously.
And
Okay, otherwise we would need to separate today. First motion, we need to notice the sheriff's office, who is in charge of courtroom security. So we're not able to address that today unless they're allowed. I don't know if you're ready to contact the person that's in charge of that today. Otherwise, we would need to separate day for that motion.
Okay.
As far as the second motion, it's completely up to the defendant. We have no standing to say anything about it. If she wants to have her documentary discovery in hard copy form, that's between whoever and whoever, but not the state of Florida.
okay, I appreciate that, sir. Ma'am, with regard to your request for discovery, or the hard copy discovery, you've advised me multiple times seeking to use a laptop. I have written correspondence from you asking for a laptop.
The judge is like, do you want a laptop? Do you want the hard copy? She's asked for both. It's kind of like whatever she gets, she's going to ask for the opposite just to make sure everybody knows how difficult this is. But we kind of are where we are at this point. So now he's going to get to the bottom of it and maybe they'll provide both. I'll just tell you, hard copies are much harder to deal with in the jail, much harder to keep in order, much harder to keep private, much harder to store, and much harder to bring in and out. Are they going to forget a box? And if they do, it's like when you're in jail and the bailiff or the correctional officer brings in a box and it's like, this is it. It's like, no, I'm supposed to have 2 boxes. They're like, they only gave me 1. A lot of times that can't be fixed. There's like way more issues with that than a laptop and a thumb drive. But some people like to write on documents. I get that. She might be one of those people. It really seems like they're trying to do everything they can to help her out here. And you'll listen to it here.
That laptop is being provided. At the last hearing, you advised that you wanted hard copies. You've also advised me that you live in the female dormitory, you have limited to no privacy, and you have nowhere to store anything. You have a small drawer to keep personal effects, and that's it. There's nowhere, from my understanding in communications with the captain, to place this information. There's nowhere to house it. There's nowhere to store it. You do not have, by your own admission, any place to place it.
Is that your understanding now? Are you asking me?
No, those are just statements that I know that are in the court file that you've made. You've written letters requesting a laptop. That's been provided to you.
I never.
You have written letters, ma'am, specifically asking for a laptop.
Do you know what data that is?
Without me going through all the correspondence. But when we have,
Like, do you know which one that is? Like, ma'am, of all your letters, no, but it was in there. You've asked for it. I remember her asking for it. I don't remember her asking for it to view discovery. I think she wanted like internet to research stuff, but I think she was asking for laptops in the past. I feel like I remember that. Jilly said, maybe irrelevant, but who keeps the calendars for the lawyers? Do they keep track of all these deadlines and progress themselves, or is it an assistant, a paralegal? Just curious about the logistics. So it can be either a scheduling coordinator, legal assistant, or paralegal that'll keep this for the lawyers. For the most part, lawyers don't do it on their own unless they're a sole practitioner with no employees. In our office, it would be a paralegal or a legal assistant that would handle this. We come back from a hearing like this. We either have it all written down or it comes in the order. We give it to our paralegal. They plug all that stuff into our calendar so we don't have to think about it again and we don't miss any of those deadlines. Anastasia, Peter, I watched this yesterday, but was wondering, has this ever happened before where someone was forced to represent themselves, or will this set a new precedent? So I guess it has happened before in some of the cases that the judge has cited. I've never seen it happen before. I don't love the idea of it, but I understand why we're here and why this might be the test case for it.
Our hearing on the issue of the your motion for freedom of movement, where I'll notice the sheriff. We'll try to set that up for this week so that can be done expeditiously.
They said freedom of movement. I don't know if that's so she can go other places in the jail, have other places to prep, things like that. I haven't read that motion. None of that's been uploaded yet. Of course, as always with this case, if you guys are interested in that content and you find it, hit me up on Twitter at LawyerYouKnow or at Tragos Law on Instagram. Send it to me in the DMs and then let me know. Just, all over my Twitter and Instagram, if you guys want to watch it, or on this video, comment. If you want to have us break down these motions and read them together, we can do that on a future video.
Okay.
We can address that at that time. But the jail has advised me they have no place.
I have a hard stop at 4:00, by the way, because I have a 4:00 meeting. So we'll get through as much as we can in the next 18 minutes.
Store this information, these hard copies. You've advised me you have no privacy and nowhere to place them. So I'm not saying no, but I don't know how I can facilitate this for you. When you do not have a place to store it, the jail does not have a place to store it.
We have an entire property department for all of the inmates on the entire compound. I've been given permission also by Sergeant.
Who?
Corporal Ward, Sergeant Dunn, Sergeant DeJesus. I'm having understanding that I have been forced to represent myself.
Somebody said the freedom of movement is for her not to have handcuffs on in court. Okay, I don't know what's in her. So I've seen freedom of movement motions to be in multiple different ways in multiple different areas. So we'll have to wait and read it, but that would make sense. I don't think she should be cuffed based on her situation and the situation she's currently in, representing herself right now, taking notes in court, representing herself. She's right. There are places to store things, but it's not always easy. It's not always accurate. Oh, he read it. My bad. I skipped it. My bad. I'm trying to get through as much of this as I can.
And have temporarily given me a property bag where I can store additional case documents at my bunk. Help me understand, please, for future reference, so I know how to approach. By my statements that I have made to you, questions were not asked in order for you to come to the conclusion that you are coming to that I did not want my hard copy. I was never formally asked by you to see if I wanted my hard copy discovery. I would believe it was the court's understanding, the judge's understanding, that it should automatically be allowed to give to me. My understanding and trying to explain to you also, so you have an understanding, is my limited restricted access to the laptop is from 8 to 4. I, with 62 days left in order to defend myself in preparation for trial, would like to close that laptop at 4 p.m. and then take out the discovery of hard copy in the 2 boxes that I have. I haven't spoken to the captain yet. I just now received the protocol for the laptop. I know that you had mentioned it to me the last time that we met with one another. So I'm confused how everyone is confused by me coming to the court with solutions and ideas and suggestions, but are being misinterpreted and misconstrued like my order, my letter from my attorneys, and you're coming to the wrong conclusion.
I'm not coming to any conclusion. The process was created, and I'm just reciting what you've said to me at prior hearings, man. That's all I'm doing. You've told me you have limited space. You've told me that you have no privacy, and that you have a small drawer.
He's like, you gave me all these issues, and I found a problem that solved them all. Now you're saying you want it both ways.
Effects. This is the first time I've heard anything about you having a locker or some kind of bag, a property bag, that you now have access to. That wasn't addressed at our last hearing. This is the first time I'm hearing about it. So I'm not drawing any improper conclusions as identified for you with the process. The jail created this process. It was something that they put together. And as I told you, we worked diligently to move forward, to get with the jail to have this done. There's no nefariousness here. There's no undermining. There's nothing along those lines. I want you to have this information. And as I addressed at the last hearing, I could not copy it. I can't look at it. I can't look at what's in those 2 bankers' boxes. Ms. Berrios cannot. No one associated with my office can look at it. We had to use your investigator to do that. And what the jail has advised me is that they were not in a position to take both those bankers' boxes because of space and potential hazards. Now, if something has changed and the captain advises me that you can have those documents, I don't have a problem with you having them. But what I've been advised, as identified in that protocol, is to how and when you can have access to the information. And unfortunately, it wasn't in physical form. It was in digital form. And that was the process that the jail created. They are aware it's 2 bankers' boxes. They're aware of what the information is. Everything has been out in the open to address your concerns and how to facilitate getting this information to you. No one's withholding anything. No one's trying to hide the ball.
My opinion differs. I was never asked anything, just like my letters to you prior to you working for my counsel, I was never asked anything in order for you to have a better understanding.
Ma'am, I'm not going to revisit that.
I am not, you never asked me in regards to the hard copy.
Hang on. Yes.
How quickly can we have an evidentiary hearing with Captain or whomever we need?
My understanding is she's on vacation this week.
Okay.
So, which is why Sergeant Casey was here, because Captain DiGiovanni is on vacation. And I cannot recall off the top of my head when she's set to return. She's set to return on the 12th.
So if the document, what would be the process? Because it's marked, tagged, and in evidence, so there would need to be a motion to get it released from evidence.
I mean, I would entertain an or tennis motion to have it released from evidence. The concern as, and Mr. J, this is the first time I had the opportunity to discuss this case with you. I know I've been dealing with Mr. Castropori. We had a hearing, and I'm sure you're first on this, but let me just kind of bring you up to speed. We had a hearing in June, and at that point in time, I forfeited Ms. Boone's right to an attorney based on her conduct and alternatively a waiver. And I'm sure you've read it. Thereafter, the court endeavored to figure out how to get those two banker's boxes that Ms. Cashman had provided of. If the jail says, yeah, we can facilitate and make that happen, her getting that information. I'm just traveling with what I've been provided, and the protocol that was provided to me that's been filed in the court file was not inclusive of providing her hard copies.
Actually, I'm just trying to find a solution. So
Same.
if she moves or tennis to release those two exhibits to her investigator, then perhaps he can try and get them released to her. And if he cannot, then it sounds like on the 12th, we can revisit this when the captain's back.
I think she,
So basically, this is them trying to figure out a way to get Sarah Boone the hard copy documents, which it looks like they do, and they are going to be able to do that. So she'll have a laptop and the hard copy documents, everything she needs to prepare her defense. They're really working to try to get her what she needs, which I respect and I'm glad for. I don't think it's going to be that helpful, but I think she's going to keep asking for things. And it seems like they're going to work together to give her as much as they possibly can, which is not uncommon for pro se defendants.
I don't know if she returns on the 12th, if he has to attempt to get you these hard copies. Is that something that you would like the court to, would you like to follow with the state's suggestion and ask about it at the court orally this morning?
I'm not understanding what it is that he's trying to do. May I please propose
Yes.
that the hard copies go to Mr. Lane, and then once I have permission by the captain and whomever, you can release them to me?
Granted.
No objection to her motion.
Okay. Mr. Lane, thank you for staying, sir. I appreciate you. If you could come back up here, sir, and take that on 30, if we need to address the jail's position in taking hard copies if Mr. Lane's unable to have it delivered. Mr. Lane, you advised earlier when Ms. Boone did inquire with you as to when you might be able to go visit her. You said the end of this week or by next week. If when you go to visit her by the end of this week or next week, bring that with you and see if the jail would be in a position to take it. If they are, I'm going to ask you to file a similar notice, sir, that that information was provided to the jail on what date and to whom. Okay. All right. Thank you.
Your Honor?
Yes,
They're
ma'am.
trying to find solutions to her, which is great. Does she have any legal assistance in jail? Mostly the only legal assistance in jail is other inmates that tell you what happened and how what their lawyer said and blah, blah, blah. Sometimes law enforcement officers in there will try to help out some of the defendants. Sometimes lawyers that come to talk to other clients maybe be like, yeah, I'll tell you this, or write a citation down for them, but not officially, no.
What would the hearing be for on the 14th then for the jail taking?
The hearing on the 14th, ma'am, would be if Mr. Lane is unable to have the jail take physical custody of those two boxes for your review outside of the laptop, we would have a hearing to address what, if any, protocols the jail may be able to utilize in you having those documents. Maybe not be necessary. We're going to go ahead and set it. If we need it, if we don't need it, we will not have a hearing.
Thank you. And then so there would not be meeting to be made at the evidence control sheet right now. It has been passed to Mr. Lane.
As of right now, the court minutes are going to reflect that what was pre-marked as A and B from the June 28th hearing is being provided to Mr. Lane.
Thank you.
Okay. With regard to your reasonable freedom motion, I'm going to set that for this Friday. Is the state available at 8:45 on Friday?
No, I looked at it, please.
That is the 9th, ma'am. Okay, I'm going to hand file both of these motions with Madam Clerk, okay?
Thank you.
All right. Is there anything else we need to address this morning, State?
Not from the state.
Anything else we need to address, Ms. Boone?
Please bear with me just for 1 moment.
Uh-huh.
What was the conclusion for the sensitive issues of having the media incorporated in the courtroom?
I need to research that matter a little bit further before I can make an order that would prohibit media access.
Do you know what your deadline may be or
She asked again about media being in the courtroom. Can we get them out for certain things? He said he needs to do more research.
estimated?
That'll be well before the 3rd. That's deadline is set for September 3rd at 9 a.m. We'll have that viewing. I will endeavor to get that done as quickly as possible. Ma'am, you also had asked for a list of the persons that Captain DiGiovanni had provided. The names of the persons at the jail regarding the laptop protocol is Captain Giovanni, Donald Casey, who was here this morning, Stephanie DeJesus, Sonia Robin.
To address the state directly.
Yeah, you represent yourself, absolutely.
How,
He said, can I talk to the state directly? And he said, absolutely, you're representing yourself now. So now she's talking directly to the state. And it's interesting what she wants to get to. But before we get to that, hi, Peter, can she mention to the jurors she was forced? So it would be inappropriate. She's not supposed to. The state definitely can't. The judge probably won't. I wouldn't expect anything like that to come out of their mouth because it's not relevant. She may, though, inappropriately mention it, but it would not be very smart because do you think the jury's going to feel bad for her and think like, oh, she must be really great if the judge forced her to represent herself. I know she would be trying to garner sympathy, but I think most jurors would be like, what did you do to get that? Because we know judges just don't do that very easily. So I think it would backfire if she did. I would not expect her to.
Do I go about getting a copy of my phone or utilizing my phone? Is that something that can be brought to the courtroom? And
To utilize a copy of her phone and to utilize her phone. That's what she's asking for from them here at the end of the hearing.
during the evidence, really the physical evidence, that I might be able to utilize that?
So my understanding is there was imaging done on your phone with software called Cellrite, and that is part of the digital discovery that's been provided to you. If you are talking about the physical device being re-examined by your own expert, then you would need to find and retain your own expert to do that without giving you legal advice or suggesting that he is the person you hire. I know that defense attorneys in this area hire somebody named Richard Connor, Connor, and then that will be between.
He's like, yeah, we have this thing called Cellbrite to download. There's this defense expert, Connors. Lots of people hire him. You should hire Connors. Just imagine that. Imagine that in some other cases and the battles and the fights, you know, like the state, do we think they're going to recommend the best expert or an expert they like to work with or have worked with in the past or is easier for them to work with? It just, none of it feels right, right?
You and AAC about, and him, whether or not he wishes to work for you and at what rate, so on and so forth. And then that examination will be done by him, with us being present and wanting to be present.
Yes, I have reviewed, I believe, 2 or 3 different thumb drives were given to me at one point, where I researched all of them extensively, also included with Mr. Lane, and it is nothing of use. It's primarily cookies and history and so forth. So that's why I don't understand who it is, the legal expert that can give me a mirror download of my entire phone in regards to videos and pictures and contacts. I could probably supply a witness list for the later if I were to have accessibility to my phone in regards to my contacts. That's why I didn't know if it would be allowed to have my phone visible here in the presence of everyone, including.
And it sounds like she wants to look through her contacts so that she can find numbers to call people potentially to be witnesses. I think all of this is wrapped into one.
Law enforcement to be able to physically look at my phone and go through it and see what I can extract myself while here in the courtroom before trying to figure out how to locate and contact an expert to download all of that to receive.
So all that information should have been downloaded, and I'm not sure what has been provided to you, but we will be double checking that.
And it's not been provided.
Yeah, your contact information, all the videos and photographs, everything on your phone should have been downloaded. And what you may have reviewed is just a PDF file called the timeline. There's additional data there, and we will make sure you have that. And then when it comes time for our digital evidence deadline, which I hope to exceed well before 9/3, we will be identifying which portions of it is of your phone, if any, that we seek to introduce at trial. So it may be texts from December 2nd, 2019, whatever it is. We will identify those pages, we will identify those files, because obviously your entire phone, however many gigabytes it is not going to just come into evidence, because like you said, there's so much of it that would be not relevant.
Yes, thank you. So you all have already had access to my phone and have researched it fully?
We're not going to talk about our work product. I'm telling you what, based on my experience from other phone examinations is, all that information should be there. And it's typically presented in 2 different fashions. One is a large PDF, typically hundreds of thousands of pages, depending on how much you use your phone every day. And then there's a separate big digital image file that is read with what's called a UFED reader. And then that is where you can go in and look at everything.
Yes, sir, thank you. I'm not seeing any of that.
We were going to make sure that that's taken care of.
And that, just as clarification from a court perspective, is that something that would have been provided in discovery to prior counsels?
Yes.
Okay, then ma'am, as Ms. Cashman identified, she had everything. It's already been digitized for you. And to the extent you're able to have the hard copies, it'll be provided to you. So you'll have access to all that information today when you return from jail.
Yes, thank you. None of it was gone over in any way, shape, or form with Ms. Cashman or in Briar. So this would be a milestone, that big milestone for you to be able to finally do that. So now if I don't have what I need or I'm looking for, how do I go about, I know you all can't tell me because of legal matters, but do I need to write a motion? I don't know what I need to do in order to finally get a copy near download of my phone. It should be brought to you for physical, for the other physical.
So again, that's going to be something that requires an expert. And then if we get a defense expert, the JAC pays for it, then we make arrangements to meet with that expert. That expert will have the
Again, just imagine all the stuff she wants to do. Every time she has to get an expert, put all the information in, get it approved by JAC. JAC has to pay that expert, and she has 62 days. Everything takes time. They haven't even been able to give her the discovery yet, and she's supposed to do all this in 62 days. I'll just tell you, just from experience, defendants always want to do a lot more digging onto certain things. And they'll say you're going to find something. And when we do the digging, we don't find it. Like, you know, cell phone data, this is going to be their talk to this witness. They're going to be great for me. And we call them and they're not great. You know, so there's a lot of stuff she's going to want to do, and it's going to be impossible to do in 60 days. And maybe that's some of the rub between her and her attorneys in the past.
opportunity to image your entire phone just as we did, and you all can work with that image. And you're going to be, if you don't already, on those thumb drives that Mr. Lane has, if you don't already have the full extraction and not just the PDF timeline of your phone, you're going to make sure that that is provided.
Okay, so that is not able to be included in the other visible evidence that you will find.
No, what I'm saying is there's two different ways that I see phone extractions. One is the PDF, which is what I think you're referring to, is the timeline of this communication, so on and so forth. And then there is the actual ginormous file that is read with a UFED program. And all that should be provided to you. Hopefully your laptop can use it. It does take some specifications on the computer to open it. In fact, we're addressing those issues at our office with our own computers. And if it doesn't work, we will cross those bridges as we get there.
They're having trouble opening certain things on their own computers. Imagine what it's going to be like her by herself in jail using a computer that has all sorts of protections on it. There's going to be things she can't open. Just you can guarantee that. And we're going to hear about them in motions, and she's definitely going to complain about them, and maybe rightfully so.
I've worked with Mr. Lane before. Just let him know. Mr. Lane knows how to find me. We will work this all out and get what you need.
Absolutely, yes, I am grateful for your information. Just to clarify, please, during the physical evidence and viewing that here in the courtroom, am I not able to physically open my...
Amanda, because everything takes forever. And it's miserable, but it's just how it is. Everything takes forever.
phone and search through it?
No, because
Okay.
it needs to be a Faraday box where radio signals don't come and go, because anytime you turn on your
She
phone.
wants to like open up her phone and use it. They're like, no, it's evidence. We can't do that.
the contents of the phone.
Thank you
You're
very
welcome.
much.
Ma'am, do you have any other questions?
Everyone is aware that I'm in the process of trying to talk to the captain. And handcuffs, okay. Your Honor,
Yes, ma'am.
I believe I am okay right now. You and I do not have a direct way of communication, and I didn't know another big hurdle is if the laptop has internet access where I don't know if emailing or messaging or whatever, however it is that you and I can communicate. Rather than snail mail, I'm writing a letter. I don't know when I write a letter how soon you receive it, because sometimes it's days or weeks that it's uploaded to the clerk's website. Do you have a general time frame of when you actually know something? Because you already have my address correction, but I don't think updated.
It's been updated now.
Money on the clerk's website.
I can't speak to what's on the clerk's website. I know for the purposes of my records and getting information to you, that clerical error has been remedied.
Do you have any other suggestions? If I do not have internet, would my only possibility to correspond with you via mail?
That's my understanding. And you asked when I receive things. I get it as soon as I get it from in the mailbox. So we check the mailbox every day. As soon as I get it, it doesn't go to the clerk, it goes directly to me. And I review it. As you saw with the motions that you made reference to at our last hearing, that you had 5 of them, we set those for hearing immediately. And I intend on continuing to try to do that to facilitate prompt resolution to any concerns or issues or motions that you may have.
Thank you. And if I do have internet access or I'm able to put on, if it's not already, am I able to correspond with you via email?
You cannot correspond with me directly, but you can have conversations with my judicial assistant to the extent that you do have access to internet. I'll make sure to include her email address and telephone number in the order setting the deadlines that we addressed this morning.
Yes, thank you. And for any, I'm not sure specifically which JA, but as soon as something is scheduled, could you all please make sure I'm included in the certificate of service or portal?
He said
or
yes.
Whatever it is I might be attached to.
And everything that's been filed with the court, including the JAC's response, the notice of the hearing that was set for today, and the notice of the filing of the protocol. Reasonable freedom in movement. Bring Ms. Boone to the custody of the Orange County Jail.
All right. We got through most of it. Just had to skip a little bit in the beginning or in the middle. Amanda, she wants internet badly. Yeah, I got to be honest. If you're representing yourself, internet's a pretty big tool. Jennifer, at the last hearing, she was told the investigator would not be able to have the discovery before 8/5 because he would be out of town. So there were parts of that, yes, but I thought he said he might be able to get it by, or maybe you were right because his son's wedding or whatever. But again, to me, those are all really big delays. So today, August 6th would have been the first time she really was going to be able to dig into that. But that's all we got. It's 4:00. I'm out of here. It's 4:00 on the dot. That was perfect. Hit the like button, guys, if you have not already. Please make sure you subscribe to the page. Hit the reminder bell if you're following this trial, because we won't miss a thing here. And let me know if anything else pops up in it that you want us to break down. But that's all we got. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.